All right, who's here on James Brandyberg?
I am your.
Mr. Brandenburg?
Mr. Brandyberg, what happened to you?
We had a shakedown and they actually, the search pepper sprayed somebody. I threw up on the bunk, so I got up to get some clothes to actually wipe it off. And they actually pulled me off the top bunk from moving during the shakedown, so fractured a finger, dislocated my shoulder.
Oh, gosh. Well, I'm sorry to hear about that. All right, so on this case, it's scheduled for jury trial?
It is, Your Honor.
Okay,
I know that he's not in clothing. I apologize for that. I don't know what happened, but I'll take responsibility for it.
okay.
Mr. Saldana and I have been talking about the case. I do think that we are close, but we are not there right now. And I am asking if you consider giving him another setting for us to continue negotiations. And also for me to make sure he's properly clothed next time.
All right, so y'all are close, but you're not there now. Why do we need more time to get there? Or do we just need more time for a jury trial for him to be dressed?
No.
Because
Well, without getting too much in the detail, Judge, the state is offering him time. They're not asking for much time, but we're trying to get to probation.
all right, do y'all want to discuss that some more? That's what you all can do.
We have,
All right.
and
So either something's going to happen today where this case is resolved, or either it's going to jury trial. How old are you?
41.
All right, he's 41. So he can sit over the box, think about it for a few minutes, and then you all can come back up.
if you do intend to call it for jury trial, I'll need to get him clothing,
Okay. All right.
run to the Goodwill.
Oh, we'll make that happen. Goodwill is right down the street. I had to run for my client there once who decided he wanted to represent himself, by the way, but I'm running to get him clothing. And then everybody was like, why are you representing yourself? You're too young. So,
Yes, Judge, we'll continue talking.
all right, thank you. Ah, sorry, Bashan, you can't hear? All right, I'll talk louder. April Garcia? All right, she's scheduled for jury trial. We'll call you back.
Okay, Judge, do we just,
Come back here by 11:30.
11:30?
Yes,
Okay.
thank you. It's gonna be a crazy day. Should I not put that out there?
You already did, Judge.
I can't even take it back. Can't pull it back. Can't moonwalk it back. But Sean, can I moonwalk that back or no? It's already in the universe. All right, could I have the parties on Eric Cantu? All right, so those who are in the box, no talking behind the court reporter. You'll have to move to that end of the box. Just ask the deputy to move you. All right, court is calling 2024 CR 1237 and 2024 CR 1238, State of Texas versus Eric Nathaniel Cantu. Can I have parties announced for the record for the state?
Brian
The
Powers,
defense?
Your Honor.
All right, and counsel, you need to be over there. And for the defense,
Brian Powers, Your Honor.
and are you Eric Cantu?
Sure.
State, are you proceeding on the indictment as presented in each cause number?
Yes, Your Honor.
Did you understand in each cause you're charged with evading arrest, detention with a vehicle? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, in each cause number, the court could sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes.
Are you a U.S. citizen?
Yes.
All right, in each cause number, according to the plea, there's a $2,000 fine. State recommends deferred adjudication. The cases will run concurrently. State will take in consideration 723-118, 711-738. There's to be restitution in 723-118 and 711-738. There's to be a 2-year driver's license suspension. Did you understand that to be the plea?
Yes.
Outside the agreement, the state is requesting that your community supervision be for a term of 7 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with the complainant or Walmart, and there's to be no driving as a condition of probation. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, sir.
Then in the cause number ending in 3-7, how do you plead? Guilty, not guilty, or no contest?
No contest.
And the cause number ending in 3-8, how do you plead? Guilty, not guilty, or no contest?
Contest.
All right, off the record for a moment. So everyone, excuse me, in the box, everyone, you all need to learn how to whisper. It amazes me that when people are before the court, you can whisper, but you can't whisper when you're not before the court. If you cannot whisper, then you cannot talk while we're on the record. Does everybody understand?
Yes, Judge.
All right, so we're back on the record. In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after giving states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt if you've applied for deferred adjudication. Are you proceeding with sentencing?
We're requesting a PSI, Your Honor.
All right, why?
Your Honor, with regards to the last recommendation for Eric, with regards to the state is asking that he not be able to drive. Currently, he's employed in a position where he delivers, he's delivering food for funds. He has a dependent. We've also have an affidavit from Dr. Punjabi, which we can provide it after the PSI with regards to the doctor's opinions on his progress with therapy, how he's doing, and his ability to get out, be able to drive and be a responsible driver from here on out.
Okay, I don't understand how a PSI is going to tell me whether I should let him drive or not.
We thought having some more background might be able to assist, Judge, with
If
that.
y'all want to give me background, you can.
Well, at this point, Judge, as far as the state is recommending a 2-year driver's license suspension,
Mhm.
we would like to apply for an occupational driver's license so that Eric could continue to work as he has been doing. And so.
I mean, well, the occupational license is something that would come at a different setting, not at the PSI, because y'all have agreed to a license suspension.
Correct, Judge. But what I'm saying is afterwards, if the court was allowing Eric to be able to drive for employment purposes, to be able to do that, then we would seek an occupational at that point in time.
All right, so I don't understand. If y'all want a PSI, I will give you one. I just don't understand what different information the court would have that you would want me to have that can't be told to me now.
Well, Your Honor, if that would be the case, then.
I mean, if
basically-
y'all want a PSI, I'll give you one, but I just don't understand what information. State, will you have any objections to defense telling me what information he has? Or do you want a witness here for that? All right, so do you wish to have a PSI or no?
Your Honor, if the court feels it would be a futile gesture in this point, then I'm happy to tell you that, Eric has been extremely active with regards to his therapy, trying to redress the trauma that he suffered for this. Over the last few months, he has been working as a delivery driver, and he's been doing very well at that. I've spoken to the mother of his child who says that he is actively contributing to basically her welfare as well as the welfare of the child. So, I would just ask that the court take that into consideration so that Eric can continue to do what he's doing. If the court feels that there's some other form of monitoring, but we feel that taking away his ability to earn a living the way that he has been, it would be of more detriment than anything else. So we would ask if the court is going to assess any type of monitoring sanctions that they do so, but not at the cost of him being able to drive and earn the living the way that he has been.
All right, let's start with this first. My understanding, he's currently on GPS.
Yes.
All right, state, do you have any objections to the removal of GPS? All right, so GPS is going to be removed. Now, the next thing we need to address is his ability to drive. This is the court's concern. He has 2 evading arrests with the vehicle. 1, an accident occurred. I think a car was damaged. So why should he be driving? Driving, I understand that everybody, if you pass the driver's test, you have a right to, take that license and drive, but it's sort of a privilege. And if you're not abiding by the rules, why should you be allowed to drive?
Understood, Judge. And if I may, as of recently, he actually was pulled over for a turn signal violation. The work that he's been doing with Dr. Punjabi and therapy with regards to his fight or flight mechanisms, it to the point of where whenever he saw the red and blue lights, he didn't hesitate. He pulled over, he was compliant. It was a warning, but just to kind of show that the progress that he has been making. We believe that the stuff that he's been doing with the doctor to try to redress these issues, he's doing well with it. And we just ask that he be given the opportunity to show the court that he can do it. And he's very well aware that if he messes up, he's looking at 10 years. And he's here today showing accountability for the actions that he's taken. So we asked the judge that he look at the growth that he has been making. I've provided, I believe, the court with 2 letters from Dr. Punjabi in the past to show the efforts that he's been making. We ask that they take that into consideration, allow him to continue to make a living, do what he's supposed to be doing as a member of society. And we don't believe that this court is ever going to be troubled with Eric again. However, he's under the he's understanding of what could happen if he does mess up, but we don't believe that it will come to that.
All right, and what is this theft case about?
That was a shoplifting last year, Walmart, Your Honor.
Okay. Right, state. All right, is there anything you wish to say?
Yes, when this happened at the time, I was just scared. I was sorry to the person. I never want to go through this ever again in my life.
Well, why did you continue to drive?
I was scared.
No. I mean, well, let's backtrack a little bit.
At the time, just a lot of things were going through. I couldn't. But also, there wasn't like a safe place for it.
No. I mean, according to what I read in police reports and the stipulations, one is playing loud music, which I understand why people think that everybody wants to hear your music. So that is ordinance violation to be playing music so loud that it's damaging to others, which I've seen people do. So an officer's trying to pull you over from. So why didn't you pull over?
At the time, I feared because the way he came on the side of my door, there was an accident that happened to me. I went like in 2022. I just got triggered by it. And I didn't understand why he was doing that. I just.
All right, and then the other case where you're just out speeding, they're not trying to pull you over for loud music, you're speeding.
Yes, I don't want to make excuses or anything. I'm sorry. I never want to go through this ever again. I'm not just doing nothing. I'm trying to get help from it. I'm trying to do better.
No. And that you've made progress, right? But I'm trying to figure in that case where you're speeding and they're trying to pull you over for because you're going very fast. Why didn't you pull over?
Well, I was in a city that I wasn't familiar with, and
City
Okay.
judge. And it was an unmarked, it was basically a blacked out patrol vehicle that was behind him.
No, but why didn't you pull over?
so I'm just paranoid. I'm always on my phone, not while driving, but when I'm at home, I'm like videos of people impersonating. It's a pretty common thing, and I didn't police on the car. I've never seen like a truck cop, like a F1 cop. I've never seen that. I was in a city I wasn't familiar with, and this will never happen again.
All right, and why did you commit the theft?
At the time, I was just really bad in the head. I was not getting help.
It was a matter of a few months after judge. He awoken from his coma. This was early, I believe early last year.
All right, so why did you at Walmart?
Well, I was just not thinking clearly. It won't happen again. I promise you it won't.
The questions?
Nor the defense, Your Honor.
All right. What the court is going to do in each cause number, there's a $2,000 fine. It'll be probated. Numbers were wind concurrently. Does anyone want to speak towards length of probation? 7 years deferred adjudication, removal of GPS. There'll be the defensive driving course. Taking consideration cause 723118, 71138. There's to be rest in 72318 to Tiffany Johnson. That's with the Y. And there's to be restitution in 71173 to Walmart. There's to be a driver's license suspension. How old are you? So how far did you go in school?
I graduated early when I was 16.
All right, so what are you planning on doing with the rest of your life?
Right now, the therapists, the doctors that I go see, I have a pending scholarship to be a civil rights advocate. So that's what I want to do. I want to purchase properties and
You're going to do with your schooling? Are you planning on doing something else with your schooling or no? Like, are you planning on going to college? You're going to a trade school? What are you doing?
college.
All right. There's going to be 200 hours of community service restitution. That will be waived if he's enrolled in. Do you have any children?
Yes,
How many? Age?
9 months.
All right. So 100 hours will be waived if he's in college, enrolled at least 6 years. Usually I require 8, but you have a 9-month-old. Ask for parenting classes. And then once those parenting classes, the other 100 hours will be deemed satisfied. There's to be of employment within 45 days. There's to be no employment as a home health care provider for minors. If your drug tested today, it's going to be.
You'll be clean, Your Honor.
No. What are the results going to be? Because you're trying to take the test, you will.
Clean.
All right. There's going to be a UA by 4 p.m. Yes. So there's going to be a UA Wednesday. There's to be regular reporting by Zoom or in person, regular random field visits. 1 time per month for 4 months. Probation's discretion, and there's to be no driving. I'm not going to say no driving length of probation, but there's going to be no driving until the decides to allow you to drive. So your attorney will need that at a later date. Do you understand?
Yes.
So I'm going to say no driving until, and counsel ever feel that, yes, he needs to start driving, then a motion to let the state know, and I'll hear a party's argument on it. Probation, is there anything else he needs? Is there anything in the court to be successful?
No.
All right, we can go off the record. In this court, in order to be successful, probation communication is key. If you have an issue, let your probation know. If you feel as though the probation officer is not addressing that issue, you can always come into court. Do you understand?
Yes.
All right, good luck to you. Just have a seat and go over conditions with you. All right, is this still going to be a contested or no? All right, court is calling 2019 CR 8716, State of Texas versus Andre Alonzo Moody. Are you the same Andre Alonzo Moody who was placed on deferred adjudication in 2019 CR 8716 for the offense of assault, family choking, strangulation on June 24th, 2020 for a period of 6 years and extended for a total of 3 years? Is that you?
Yes, ma'am.
State?
Moving forward with condition number 2, on or about the 24th day of April 2024, in Bear County, Texas, the defendant Andre Alonzo Moody did then and there fail to submit to drug testing as directed by the court, court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Judge, we ask the court grant the motion or deny the motion, enter adjudication of guilt, and sentence him to 6 years, probated by 6 years.
All right, so is this the proposed agreement?
Yes,
Why? Why should I do this? He's been here before on a motion to revoke. This is not his first motion to revoke. And the court has addressed issues with him and addressed issues with him. And nothing is happening. We're still here. I've even extended him. So I don't understand why he shouldn't be revoked.
Judge, he has completed those courses. I think he was gonna do another round of BIP as well. This would be a conviction for the state.
Why would he do another round of BIP?
It was open there on the court summary. I know that he completed the first one. That's what it reflects.
All right, in his motion to revoke, I'm not considering it, but he has a violation of condition number 1. What's happened to that case?
That's supposed to be rejected.
All right, is it being rejected because he's entering a plea to violation of condition number 2?
No, independently.
I still don't understand. Why should he be continued? Probation
Yes, sir.
on Mr. Moody. What is probation's recommendation? All right. So I don't understand why it should continue him.
It's a revocation and then putting him back on probation, straight probation. 6/6, but I think, oh, was it because in this beginning, the state had mentioned denying the motion? They meant
No.
grant.
No, here's my problem. He's been on probation before. A motion to revoke was filed before. He was continued. Now we're back here again for another motion to revoke. And I'm being requested to continue him. I don't understand why I should continue him. It doesn't appear that he's being successful.
For mastery.
No, I mean, nobody wants to go to prison. Everybody asks to be continued. I'm just trying to figure out why should I continue you when we've been here before?
Or,
You want to raise your right hand? Do you
Yes.
solemnly swear and affirm the testimony you give will be the truth, and nothing but the truth, so help you God?
yes,
All right, you can lower your hand, state your name for the record.
Andre Moody,
Why are you not taking your drug test? Because that's what you pled not to doing.
yes, ma'am. When I went up to the, to go take my drug test, I had $8 in cash. And I had the remainder on the card. They didn't accept it like that. Currently, at that time, I had, lost my apartment. I was paying.
All right, wait, let me stop you right there. So you are saying that you went to go take your drug test. They were charging you a fee. You only had $8 and they wouldn't accept the rest from a card. Is that what you're telling me?
Ma'am.
All right, probation. Can you have somebody zoom in here?
Yes, sir.
All right, somebody's going to zoom in. We're going to find out what's going on with the drug test. All right. Thank you. All right, who's here on Michael Bora?
Here you are. He's right there.
All right, come down, Mr. Mora. All right, what's happening on this case with his psychological evaluation?
I walked over and talked to Angela this morning. We should be receiving the competency report from Dr. Jackson today.
Okay,
Once we receive it, there's still a timeline of a week to confirm the report and then another month to actually do the sanity report. So I was gonna request, say, October, maybe 17th, we should have everything done by then.
all right, Ms. Ferguson, I don't want this to fall off the radar. Can you recall this in 2 weeks? So in 2 weeks, that report should be done. What date?
I can do the 23rd, Judge.
All right, so we'll be back on the 23rd. And that's just to get an update on the psychological.
The 23rd, if the court would permit, I may have to appear by Zoom because I'd be in federal court,
That's fine.
but I don't know if that's.
Yeah.
Okay. Thank you, Judge.
All right, thank you. All right, Brandy Berg. All right, so we're gonna get you dressed for trial. And we're gonna bring you back tomorrow for jury trial. Do you understand? And have you filled out a acknowledgement of discovery?
Yeah, I'll check with Mr. Garcia.
All right, your plea deadline has expired. The court will not consider this case without good cause. Otherwise, you have the plea open to the court. Do you understand? Thank you. All right, Stevie Stokes,
Right, Judge. Good morning.
good morning. All right, we're set for jury trial.
Judge, Mr. Stokes, number one, we received a new offer today. Number two, Mr. Stokes, after discussing the case with him, no longer wishes for me to be his counsel.
Mhm.
So I can file a written motion to withdraw, but I'm orally asking the
All
court
right, we
about.
can go on the record. Court is calling 2023 CR 7159, State of Texas versus Stevie Stokes. Can I have parties announced for the record for the state, for the defense?
Kelly Biddle.
And are you Mr. Stokes? All right, your counsel, you want to do an oral motion to withdraw?
Yes, Judge.
Any objection to the oral motion? All right, you may proceed.
Judge, after conferring with the clients and with the client's family, and speaking with him this morning, he no longer wishes for me to be his attorney. I feel that the attorney-client relationship has deteriorated. And I don't believe he trusts my counsel anymore. And so I'm asking the court to allow me to withdraw. In addition, the client's family, not anything to do with the client, but the client's family has been has written me and has not been written the most kind things to me.
Okay, all right. All right, motion to withdraw is denied. You're set for jury trial today. If your family wishes to hire an attorney, then that attorney needs to be here this afternoon, prepared for trial.
In addition, Judge,
Yes.
I thought this case was set at impact.
Mhm.
And so I approached Judge Jarrett, who was set at impact last week, and I filed a motion for continuance, which I discussed with the state. And I got that signed by Judge Jarrett.
Well, I'm unsigning it. That's withdrawn. This is set impact. You go to impact, to try cases. This case has been pending since 2023 of September. We're coming up on a full year for this case. This case is going to trial, right? And we can go off the record. Let me explain something to you. One attorney told me when I was starting out, he said, Stephanie, when I was a defense attorney, he's like, Stephanie, you really should be winning every case that you try. I'm like, what? How can this be done? He said, if we can write our own facts, we can win every case. Guess what? Can't write your own facts. Your attorney looks at the police report, maybe talks to you. If your family were not present, he can talk to them or not talk to them. He represents you. The state will tender an offer because in this court, I require that the state tender an offer. Your attorney then is legally and ethically obligated to give you that offer. You can think it's a ridiculous offer. You can accept it or not accept it. You can say, you know what, I won't accept this, but I'll accept offer B. And then your attorney will give that counter offer to the state, and the state will say, we're not offering that. We're only offering what we've already offered you before. Otherwise, we're going to trial. Then your decision is either you want to go to trial or you don't want to go to trial. Your attorney cannot make the state dismiss the case. They can't make the state give you an offer that you feel that you are deserving of. So this is going to trial today. It's been around for too long. All right.
Judge,
And here's the thing. I always tell people, treat everybody with respect. Treat everybody with respect. Yes.
But I wanted a bench trial.
All right. Well, you can talk to your attorney and see if he wants to do a bench trial. If he wants to do a bench trial, then I will hear it. And this is what I will tell people about a bench trial with Stephanie Boyd. It can be a capital murder. If it's a capital murder and somebody decide they want a bench trial and we go out through the steps for there to be a bench trial, guess what? If there's not enough evidence, I'm going to find somebody not guilty. If there is enough evidence to prove the case beyond a reasonable doubt, I'm going to find them guilty. The only exception to that is if my mom is on trial. Because if my mom is on trial and I'm hearing it, it's going to be not guilty. But other than that, it's guilty or either not guilty, and I just listen to the facts. You understand? So if you want to think about a bench trial, the state has to agree to a bench trial. You can't just say, I want a bench trial. And then if the state disagrees with your right to have a bench trial, they can do that because the state is entitled to a jury trial as well. But if you're coming to me and you want me to listen to the facts, I will listen to the facts and I will make a decision. But if the state is able to prove their case beyond a reasonable doubt, it's going to be a guilty verdict. If they can't prove their case beyond a reasonable doubt, it's going to be a not guilty verdict. And I think people in this court and defense attorneys will tell you, I've had cases before me for a bench trial where a person's been found not guilty. I've had cases before me with a bench trial where a person has been found guilty. I'm just a straight shooter. You understand? All right.
Judge, I need to re-urge my motion for continuance. We're missing a witness that is essential to the defense for purposes of this case because it's a baby death. I need this witness.
All right. And has this witness been subpoenaed?
They're not subpoenaed because they are. It's an expert witness, Judge. My expert witness is not available.
Oh, he can zoom in. Yeah. Your expert witness can zoom in. All right, thank you. And I don't mean any disrespect to anyone, but I know that the chiefs are not actually trying cases. They're letting you all try cases, so I'm sure somebody will be able to pick up the phone and call the chief or whoever it is you need to go to
Yes,
to see if a bench trial is possible.
yes, this is just new to me. This is
All
the
right.
first time it was done.
All right, thank you. Everybody step back. All right, who's here on Michael Bernal?
Good morning, Judge.
Good morning. Michael Bernal, come up, please. Court is calling 2024 CR 007502, State of Texas versus Michael Bernal. Can I have parties announced for the record for the state? Defense,
Nick Aguilera on behalf of the Honorable Michael Bernal.
are you Mr. Bernal?
Yes, ma'am.
Counsel, have you received all of the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. You're charged with the offense of theft, $2,500 with 2 or more previous conviction as state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine.
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
According to the plea, there's a $500 fine. State recommends deferred adjudication, and there's to be a referral to felony drug court. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 3 years. There be a TAP evaluation, 120 hours community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
If you would consider it, Judge, this morning.
All right, anything you wish to say on behalf of your client?
Judge, after spending quite a bit of time with him and the prosecutors, they saw fit to recommend deferred. He does have 2 prior convictions for theft. He is the sole provider for 2 children that were at the target with him and that Miss Benavides. Miss Benavides is locked up in jail for the last couple of months on completely separate other felonies. Dr. Bernal's main concern was his children, and he has always expressed to me that if the prosecutors offered him supervision, he'd be happy to take it, accept responsibility. He is working in the construction business. It's been a little slow with the weather, but he knows he can complete it.
All right, why do you keep stealing?
I was in a toxic relationship.
I'm sorry, what?
In a toxic relationship,
What does that have to do with stealing?
and we would always fight if I went to work. So
I don't understand how toxic relationship equals stealing from Target and
it's
Walmart.
like if I go to work and come back, or if I try to go to work, they wouldn't let me go to work. You know,
So then how are you supporting children if you're not allowed to go to work?
well, for the last 6 months, I've had my kids and I've been on my own. So I've been
All right,
working.
so who has your children?
Right now,
Mhm.
My mother-in-law.
Why you act as though you don't know who has your children?
No, my mother-in-law has 2 children.
All right,
For right now, she's.
Well, he's talking about right here in court.
Oh, yeah.
While they're in court there, he's at the mother-in-law's bed.
so where's your mother?
We don't really talk.
All right, and when you're drug tested today, what are the results gonna be?
On marijuana.
All right, and what else? Here's the thing, you need to be honest with me because I'm trying to set conditions that will hopefully help you be a better parent. So what are you going to be positive for? Possibly. We'll do it that way. Possibly, what could you be positive for?
Maybe cocaine.
All right, cocaine, marijuana, what else? All right, and is Child Protective Services involved?
Not on, based on this case.
All right. What are they involved based upon?
You explained something to me this morning that was opened last week or
Oh.
something.
Last week, I had my kids in daycare, right, so, I've been having problems with the daycare, so then, I noticed my son had a cut on his foot, so I brought it to the daycare's attention, then the daycare, got real mad, cause I told them that I'm gonna remove my son and put him in another daycare. So they went ahead and called CPS, so I called my previous CPS worker and I told her how to go about it, and then I took my son to the hospital. The hospital checked him out, said that there's no neglect, there's nothing at all, so I'm just waiting on the response.
So are you under CPS investigation or no?
They barely opened it last week.
Something was
It
open
didn't
last
happen
week
This past week.
based on something that happened at
Yeah.
daycare.
All right, so here's the thing. He shouldn't be around children because he's using cocaine and marijuana.
Understand.
And then I'm looking at the police reports and there's a video of you carrying a child out of Target as you all have
Yeah.
stolen.
I wasn't feeling them at that time.
No, it says in here that you were the lookout.
No.
You wanna-
No, yeah, well, yes, no.
All right, being the lookout is as though you stole.
Yeah, same thing.
Yeah, legally it is. So I don't understand why you won't stop stealing. And I don't understand how toxic relationship equals, therefore I'm stealing. She won't let you go to work, but she'll let you go to Target to steal. I mean, is that what you're telling me? She won't let you go to work, but
Like,
she'll let
no,
you go
no,
to
no.
Target to steal?
No, she just wanted to be around me all the time, watch to see what I'm doing and, thinking I'm cheating or some stuff.
And what's that diamond tattoo about?
It's supposed to be for my kid. I was supposed to color it in with my kid's first stone color.
All right, this is what the court is gonna do. Court is gonna sentence you to 4 years deferred adjudication. There's gonna be regular reporting by Zoom or in person. There's gonna be regular random UAs,
Sorry.
proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. 120 hours of community service restitution. I'm gonna order parenting classes. Once that's completed, the community service hours will be deemed satisfied. Cats 1 and 2. There's to be no contact with Felicia and Benavides. Field visits 1 time per month for 4 months upon release from custody. There's going to be a TAP evaluation and felony drug court evaluation in custody and CPS compliance. Probation, is there anything else he needs? Is there anything else you need from the court in order to be successful?
I don't believe so, Judge.
And also probation, there's going to be no unsupervised contact with minors until further notice. What I can tell you, because it's Monday, felony drug court will probably be able to see him by Tuesday and they'll be done with their evaluation by Tuesday. If you're honest with them, you'll probably be released on Wednesday because they'll accept you into their program. They're having a graduation, so there'll be placement for you. If you're dishonest with them, they're going to say you don't need help and they won't accept you in the program. And then for the TAP evaluation, it'll be about 2 weeks. All right. Good luck to you. And I'm doing it to protect you and to protect your children. Okay.
Yes, ma'am. Thank you.
All right. You're
Thank you,
welcome.
Judge.
Thank you. Can I see the parties on Moody?
I'm sorry, Judge.
Oh, no problem. All right. So we're back on the record in 2019 CR 8716, State of Texas versus Andre Moody. All right. So we do have Officer Siddell here. Does anyone wish to ask him any questions?
Yes, Judge, if I may.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
You do.
All right, you can lower your hand if you'll state your name for the record, please.
Michael Seidel, Community Supervision Officer, Bear County CSCD Office, Unit 7.
All right. And to the court reporter, that is spelled Seidel. And could you all not send anything else to the printer since we're by Zoom? All right, you may proceed, defense.
Mr. Seidel, do you have any knowledge on whether or not Mr. Moody showed up to get a drug test and was denied the opportunity to do so?
I do not have anything specifically in regards to that.
Judge, I think this might be the wrong witness.
All right. So do you know when he was scheduled for a drug test? Is there any way to check?
Yes, he was, he said that he would submit a drug test that day, April 24th at our meeting.
All right, so is there any way for you to check with the facility to see if he actually submitted or tried to submit a drug test on that day?
They do not have a record of him attempting to submit a drug test that day.
All right, and do they place in a file or something that says he didn't submit or attempt to submit?
Yes, there would be a record here in their database, and there is not.
If someone showed up with the incorrect amount of money, would that be reflected on that database?
No. They would all, in the database, it would be if they tried to submit and didn't, or if they didn't come back or something like that, but not if they didn't have the payment.
All right, so that it can be very clear. If someone were to show up for drug testing, do they have to sign in?
Yes.
All right. And if they sign in and don't have money, will it still show up that they actually signed in and appeared?
In what I have access to, I do not have that. It would not show in what I have access to.
But would it show up that he even appeared, regardless of whether he was able to pay or not? Will they take his name down that he actually appeared?
That I don't know.
When can we?
Judge, so we would have to move this to like a contested hearing. The people from RMS would have to be subpoenaed in order to be here. If it's gonna be, we need specifics on that specific day. I did reach out to Mr. Seidel to ask him about the payment situation, whether or not they would take a combination payment, cash and card. And RMS, he did reach out to RMS in regards to that, and it was confirmed that they do not take a combo payment. So
No, they would.
they would?
They would take a combo payment.
Okay. I misread the information. So at this point, we would have to set it for contested if you would like us to get RMS here.
All right. Any other questions for Officer Seidel? Well, the issue is he's saying the reason why he's pleading true with the explanation. He's saying the reason why he didn't take the drug test is because they wouldn't take a combination payment. He said he had $8 in a card and they told him no. So Officer Seidel is saying they will take combination payments. So if your client wants someone here from the facility, they're probably going to end up saying, maybe not, they're going to probably end up saying they do take combination payments. But since he's pleading true with an explanation and that's his explanation, then we'll get to the bottom of it. So we'll have them here. Yes. I'm sorry, what?
I went, like I said, I went up there, and I saw it with the $8, and that's when I had to add exact payment.
No. Let me stop you right there. Your testimony to the court was you had a payment for $8 and you had a card. And you said that they would not take a combination payment. That's what you told the court.
Yes, ma'am.
Officer Seidel is saying, yes, they will take a combination payment. So what we need to do, we'll have somebody zoom in from that facility. And either they're going to tell me they'll accept a combination payment or they won't.
Wow.
All right.
Thanks, Judge.
All right, Ms. Abrams, how much time do you think we need? 2 weeks, 3 weeks? All right, Ms. Fergus, can you recall this for 2 weeks?
Monday the 23rd.
All right, we'll be back on Monday, the 23rd.
Thank
You
you,
said
Judge.
for a contested judge?
No, it's not a contestant. It's just to have a witness zoom in.
Okay.
All right, who's here on Batius? Priscilla Batius? All right, and we're here for sentencing.
We are, but I do have a request before we get into the sentence.
Yes.
The request is for additional amount of time. There are some witnesses Priscilla and I had talked about that we wanted to present to the court. One of them is her pastor, a woman that goes by Miss Francis, who apparently is out of the country, that intended on being here today. She is in India, as I understand it. And then a secondary witness that I just found out about today, who was actually a female inmate that was actually at the scene of the incident, that wishes, she provided a letter. I've never spoken to her. I think it would be important, having just learned about it, for her to perhaps impart some information to the court. So
Is she an inmate? Does she have an open case? Does the
does.
attorney needs to be contacted?
that's exactly what I need to do. I like what I read and I'd like to talk to her, but I know that there's a protocol and I want to follow it. And I don't know how long Miss Francis will be in India. It's a long way away.
Well, she can appear by Zoom. Ms. Ferguson, on this case, recall it for September 23rd.
Yes, sir.
And she can appear by Zoom, Judge.
Yes.
Okay,
All right,
thank you, ma'am.
you're welcome. State Batius is being reset for sentencing on September 23rd. Defense has witnesses he would like to appear. All right, who's here? Luis Martinez? Luis Martinez. All right, today is his plea deadline date. Where are we? Are we asking for a jury trial?
I'm asking for that date to be extended, Judge. This is two cases, both of them from 2018. The warrant wasn't issued until 24.
Mhm.
We've had difficulty finding the witnesses from back in 2018. Just finding something. I need some more time. I'll ask them for 30 days to continue to do that background investigation and confer with him on something other than just what the state has to do.
All right, Ms. Ferguson,
Yes, sir.
can you set this for a plea deadline date in 30 days? Plea deadline date will not be extended past that point.
October 10th.
All right, October
All right.
10th. Thank you.
Thank you, Judge.
You're welcome.
Excused.
Yes. Francisco Perez. Court is calling 2023 CR 4997, State of Texas versus Francisco Perez. Could I have parties announced for the record for the state?
Yes.
For the defense?
Douglas Catmar.
And are you Mr. Perez?
Yes.
State, it appears you're proceeding on count 1, waiving count 2. Is that correct?
That's correct.
Any objection?
No, ma'am.
Do you understand you're charged with the offense of assault, family choking, strangulation? That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Second,
Did you understand?
I thought it was second degree.
No, it's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes.
Are you satisfied with the way you've been represented?
So much.
Well, that's either yes or no. If you're not satisfied, then you may need to hire an attorney. Are you satisfied with the way you've been represented?
No, not really.
All right, so you're gonna hire an attorney? Because this is your attorney.
I'm looking for another state prosecutor.
No, this is your prosecutor here. The state is made up these prosecutors here. You can't shop around for a different prosecutor. Do you understand?
Yes.
All right, so I'm talking about the person who's standing next to you.
Yes.
Do you know who that is?
Yes, that's I forgot his name.
All right, do y'all want to step back so you can talk to your client?
Yes, Your Honor.
All right, thank you.
Michael Meyer. There we go.
Luis De Leon.
It's Mueller just stepped out of which she's kind of quickly turning about its work.
The 186.
186,
Yeah.
she, when having conferred with her judge, she did indicate that she has some new discovery, that she's unaware of it.
All right, you're on this side, counsel.
Sorry about that.
What new discovery?
She has a phone that she is going to do a dump on according to Ms. Mulliner, and, I'm to drop a USB off. They just filed a notice of additional discovery, Judge.
All right, so why are we just coming up with discovery at the 9th hour?
I don't know, Judge, I'm not the state. I'm just relating to you what Ms. Mulliner said to me. She said she was unaware of this phone. She discovered it. She asked that she have a dump done. She instructed me to bring a USB by, which I will do. And that's what I'm relating to the court.
All right, so here's the thing, so that everybody can rest assured. The fact that a prosecutor is in trial in another court has nothing to do with the price of peaches in this court. That means another prosecutor would have to come down and try it. Now, this thing about the cell phone dump, does anybody know when it's going to be done?
I believe it's already done. She's instructed me to bring a USB by, and I will get that information within this week, Judge, and go through it. I'm not sure how much it is, but I will do that. And if it benefits the court, I'll try to do that as fast as I can.
All right, Ms. Ferguson, recall this for September 16th.
Yes, sir.
All right, thank you for dressing appropriately for court.
You're welcome, Judge.
All right, no, I'm talking to your client.
Oh, my
It's
apologies.
expected. I mean, if you don't dress appropriately for court, I would just, what's going on? All right, we're back on the record in 2023 CR 4997, State of Texas versus Francisco Perez. So, Mr. Perez, are you satisfied with the way you've been represented?
Yes,
Are you a U.S. citizen?
yes,
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the document? Well, part of the document that contains your plea bargain agreement with your attorney, did you understand it?
yes,
According to the plea, state is proceeding on count 1. Punishments be assessed at 3 years in the prison. The state recommends community supervision. There's an affirmative finding of family violence. There's to be mixed supervision and no contact with the complainant. Did you understand that to be the plea?
yes,
Your Honor, I'm so sorry, but he does live with the complaint.
yes.
I missed that, Your Honor.
Uh-huh.
It's supposed to be no harm.
Yes,
I believe.
Well, let me just tell you, I don't do no harmful on these type of cases unless the complainant makes an appearance. And even then, there's no guarantee that I will do a no harmful.
He is disabled and lives with his parents.
Yes,
They'll need to be here.
The father is here.
Well, but he's not the complainant.
No, he is not. Would like us to reset, Your Honor. So
What
she
we'll
could
do
be
is
here.
we'll continue with the plea and then we'll set it for sentencing. And you can have the complainant present. So do y'all wish to continue with the plea and have the complainant present?
yes,
Yes,
All right. So, did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes,
Did you understand that to be the entirety of your plea bargain agreement?
yes,
Outside the agreement, I'm trying to do 3 things at once. Outside the agreement, the state is requesting that your community supervision be for a term of 3 years. Did you understand that that's a recommendation from the state and the court does not have to follow that recommendation?
yes,
Then to the offenses charged in count 1, how do you plead? Guilty, not guilty, or no contest?
no contest.
Court will find there's sufficient evidence to find you guilty and the court will find you guilty. And we'll recall this for sentencing on, is September 12th enough time for you, counsel?
we will try to make that work, Your Honor.
All right, we'll come back on September 12th for sentencing. Norma, if you'll give him a reset date for September 12th for sentencing. And do we have the, and thank you for dressing appropriately for court. All right. What is your client's name? It is Alfredo Salinas.
Yes, Your Honor.
All right, this is set for trial. So Norma, he needs to be brought over dressed tomorrow for trial. I don't know why he's not dressed.
Yes, Your Honor, we do have a motion filed for, to be allowed to be in a regular clothes. Not sure.
Yeah.
According to the family, the jail did not allow him to get that exchange of clothes without a court order. So they deny this family access to give them the clothes.
No, you don't need a court order to sign for him to have a clothing exchange. What clothes does he have clothes at the jail?
He had some before, and we have his family members trying to give him additional clothes to be able to use for trial.
All right, Deputy Laura, can you send him back and have him brought back dressed for trial? They're gonna have you dressed. Now, see if we can get it done today.
Okay.
All right.
And Your Honor, so the prosecutors have made it very clear that our case is not gonna go to trial because there's other cases that have priority.
No, nobody makes that clear except for me. And what I'm making clear is he's going to the jail, he's gonna get dressed, and he's coming back. Jose Montares, is this gonna be contested?
Yes.
Are there witnesses for this? Okay, all right, if you all step back.
There's some circumstances that probably just need to really be discussed a little bit.
Okay,
I don't have very many options, but we do need a little more time.
okay, all right, step back and discuss.
What's up? Yeah, thank you, Judge.
Zion Taylor. All right, where's your client?
He's right here.
Hello. Counselor, you're on this side. All right, the schedule for jury trial?
Yes, Judge, if the court were to call last week, we filed the 27th actually of August, we filed a motion to withdraw as counsel, a motion for continuance and a motion for investigator. The court granted the investigator last week.
Mhm.
I've talked to the investigator. He's done some work, Judge. We filed an amended motion for continuance this morning. These are, I don't know if you have copies of them, Judge. I don't know how that works now.
State,
and
do
this
you
is
have
the
any
original.
objection to their motion for continuance? He says his client has a broken jaw and his mouth is wired shut. So I don't know if he can communicate effectively.
Well, I guess if he's gonna testify. It's been entertaining, Judge.
So,
Yeah. All right, I won't ask you what happened because I imagine it's hard to talk. All right, so I'll grant your motion for continuance.
And the withdrawal judge is denied.
Oh, yes, motion to withdraw, that's going to be denied. So, Ms. Ferguson, I need a jury trial date. All right, November 12th.
Thank you, Judge.
All right, once you sign the reset form, you're excused.
Thank you, Judge.